Hello, everyone. Welcome to our webinar, which was part two from a failed part one last month. Sorry about the technical glitch. We hope all goes well today. So we are having a webinar specially targeted at GPs, but any doctor interested in medical legal matters, you're welcome to join. So the topic is called GP Practice Shield, Indemnity and Legal Readiness, How to Insure Right, Document Right, and Act Right. So with me are two important guests. First of all, let me introduce Mr. Jafar Gopi, who is the founder and CEO of Dr. Shield. Okay, I'm sure many of you know what Dr. Shield is. So hi, Jafar.
Hello,
And
good evening
uh,
everyone.
and also with us is Miss Genevieve Vanessingam. So Jen is no stranger to us because, in fact, she gave the last medical legal talk, and I think she'll be very important to handle all the medical legal questions. So let me just go through some basic house keeping first before we begin. Yeah. Um, we would like you to ask questions. Now, this is going to be a very different format from our usual, where we previously have a talk and then Q&A. But today, it's entirely Q&A. It's for you, an opportunity for you, GPs and doctors out there, to throw your questions at Jafar or Jen, be it something related to indemnity insurance or any specific medical legal topic which is at your which is pressing for you. Okay, so the Q&A, you can join us at slido.com, enter the event code 40232213, or just use your QR scanner and it will take you to your Slido app or slido.com in the same event code. All right. Those of you watching from the dops.my website for the medical legal section, the Slido is at the bottom below the video already, so you don't have to log in anywhere. Please do subscribe to our channel, and you'll be notified of any upcoming events if you stay subscribed. And for claiming CPD points, we'll display the attendance link at the end of the talk. Okay, so just be patient. We will get to it after the session is over. Right. So let's dive into the matter. Okay, we've got 26 of you online now. Maybe you can just remind your colleagues that we are live, and this is the best chance to get your questions answered. So I will highlight the questions in the screen and at the bottom like this. So the first batch of questions are really medical legal. So Jen will take the brunt of it. Yeah. Okay, the first thing is something to do with documentation, something very important. I think you all realize as doctors and GPs. So for disputes, Jen, how much weight does proper clinical documentation actually carry when you defend a GP?
Evening. Thank you, Dr. Allen from
Yeah.
Dobbs, and thank you, Jafar, for having me this evening. Looking forward, we've got lots of questions, but as Dr. Allen mentioned, do feel free to put your comments in the section, and we hope to address it. So going first to clinical documentation, how much weight does it carry? Now, what we do know is the actual evidence in a medical legal claim is the medical records and is the documentation. So what we always advise our clients is that you have to document comprehensive, clear medical records. And what is really, really important is you have to document critical facts in the clinical management of a case. If you are giving advice, this should be documented. If a patient refuses a certain treatment or a referral to secondary care, that should be documented. Because the essence of this is medical negligence claims don't happen overnight. They don't happen the next day. Sometimes they happen in several years after the incident has occurred. So when you are going to defend your claim, you're going back maybe 5 years and looking at these medical records and wanting to recall information from this case. So yes, heavy weight is attached to the medical records.
Just to remind us, how long do we have to keep our records or documentation?
A very, very difficult question to answer, Dr. Allen, but straightforward answer would be for private clinics, private hospitals, medical and dental clinics. The limitation period to bring a medical negligence claim is 6 years. In cases of disability, that extension period is extended. So if it's a straightforward medical negligence claim, 6 years, a patient has to bring a cause of action against a doctor in a clinic. Private. Government is 36 months.
Oh, you mean disability? Let's say any adult who's disabled also, is it more than 6 years?
Yes. So, for example, we'll take a brain damage obstetric case, for example. The limitation period starts to run when the patient becomes of age. So that is 18 years under the Malaysian law. So it would be 18 plus 6 for a case of say a CP child, for example.
Okay. Maybe you can. Yes, sorry. Go ahead.
Yeah, just go on a little bit more on documentation, because it's quality over quantity. It's not that it has to be the longest, lengthiest medical records, especially in GP settings. But the problem with GP settings is it's usually, from my experience, is scanty, very limited note taking. And what also needs to be written in the medical records is a treatment plan, risks and benefits that were considered. And, you know, as much as it carries weight in a medical negligence, in defending a medical negligence claim, it's not a foolproof shield against any potential litigation. So these would be the important points I would remember when I'm note taking.
Okay. Some questions are beginning to pour in already on Slido, but I think we'll address them because we've got a series of arranged questions, and then that's overlapping. So I will get to those who've already put their questions on Slido. So just be patient. Okay. Now the thing about documentation is maybe you can share what are the common mistakes, you know, that doctors or GPs make in documentation that lead to legal exposure for us.
Right. So one of the common mistakes that we see mostly in GP practice as opposed to secondary care, because secondary care, we have the benefit of the nurse's notes, right? And other doctors and multidisciplinary coming in together and which all combine the medical records of the patient. When it's in a GP setting, the most common mistake that we see is a lack of documentation. So for example, there was a UK case which ended up with the patient being misdiagnosed with quad equina. One thing that the judge mentioned in that case was the patient presented in a wheelchair. That is something that should have been in the medical records. Another thing in that case also was that the doctor documented that there was no red flags present in that case, which was actually contrary to what happened. There was the key warning signs of quad equina syndrome that presented in that case, but he specifically noted no red flags. So what you are documenting and is very important. So the common mistake here would be lack of documentation and not documenting the advice or the risks inherent with whatever the condition is. So sometimes you might have a patient that says, no, I don't want to go to hospital. I don't want to get seen by the orthopedic. Can you just give me some medication here to help with my pain? If you are advising the patient that they need to have secondary care, look by a specialist, and they are refusing, this is something that should be documented in the medical records.
Yeah.
And
So,
another
yeah.
thing, another common mistake also, or not really mistake, but a consequence sometimes that we have seen in case law in Malaysia is doctors altering or tampering with medical records. It does happen, and it is not that difficult to see when that has happened, especially when it's physical notes. Electronic is a whole different ball game, but when there has been cases where there's been altering of the medical records, and there's a case called Dato Stanley Isaac, where the court awarded 500,000 ringgit as aggravated damages for, and one of the factors is tampering with medical records. So that's a big no-no as well.
Okay. Thanks for reminding. Never tamper with records. For those of us who use electronic medical records, I think a proper one, you cannot edit it. I mean, or at least there will be an audit trail to show what has happened. But I think in paper records, it's quite obvious if you usually try to alter or cancel or scratch it off.
Yeah. Just on
So,
that point, Dr. Allen, about
mm,
scratching out. If there is an amendment that needs to be made to the medical records, right? Instead of really making it trying to be that you can't see what the error was, do a line through it so that it is still legible, and then put your annotation beside it, the correct position, whatever that may be, and then sign beside it. So you don't have to scribble it out and make it illegible, just neatly. There was an error, maybe you said something, there was a mistake there, strike a line through, and then put the corrected version beside it with the signature and the date.
do you have to date and timestamp the amendment as well?
Yeah, that would be advisable.
Okay. So if we use scribes, some of us nowadays with AI tools, we use ambient scribes to help in the documentation process. I'm one of them, actually, highly dependent on AI scribes nowadays. And are these legally acceptable if we use a scribe as a tool for the documentation?
Yeah, so far there's been no indication that it's not legally acceptable as evidence. But like you mentioned, the risks of trying to edit, I would be cautious of that. And also in the electronic medical records, you can put in a retrospective entry, which will kind of mess up the timestamp a little bit. But if you need to make retrospective entry, for example, an emergency, just make it known that it's retrospective.
Yeah. I think depends on the EMR. Sometimes what I do is we forgot to add something. Maybe it's the next day. We just put a late entry referring to whatever visit and then enhance the documentation with the late entry. But we
Yes.
cannot edit. We can't change the whatever has been documented earlier. Or if we do, there will be a obvious trail which for the amendment. What
Because
if?
this is such a
Sorry.
new and upcoming area. In law, also we are using AI as well, but you have to be mindful of the liability of incorrect data. There may be prompts, you may be rushing, and an auto type, like an autocorrect feature may be available. You need to be mindful of any incorrect data as well.
Yeah. Yeah.
Because also, in multidisciplinary settings, someone else is picking up where you left off or referring to the notes you've written. So it's really, really important.
Yeah, I think just a reminder that before we use whatever is documented by a scribe, we are the human in the loop, we are responsible. So we need to check before using it as the final documentation. But what about templates? I mean, now also there are templates. I've seen radiology templates or some other templates where they forgot to remove an item And actually the patient pick it up and say, how come the reports mention the gallbladder, right, when I had the gallbladder removed 10 years ago? Something like
Yeah.
that.
Yeah, so the question is, can this ever backfire? Absolutely. I've also seen, for consent forms, the risks. I've seen a pre-chopped version of bullet points of risks inherent in a procedure that may be routine and inherent in that procedure, but you should be mindful of anything that is template-based or pre-filled, that you are filtering and editing it to the particular case.
Okay. I think lastly for documentation, just for completion. I mean, in hospitals, surgeons would detail their operation and as a routine, etc. What about GPs? How detailed should their documentation be for minor procedures?
Okay.
Toilet and suture, incision drainage, or even vaccination and so on. Are they
Right.
expected to be very meticulous?
Um, my answer to this would be consent should still be obtained for minor procedures. It should, if it's not, hospital settings have a pro forma for, an anesthetic consent form or a surgical or an operation note. But consent forms for minor procedures should generally outline the nature of the procedure, its purpose, the risks, and the patient's consent.
Okay.
Another point that I would like to add on this, if you're using vaccinations or any type of medical device, usually the medical device company, for example, will give you the batch number or the serial number or barcode. They will usually give you sometimes some additional stickers that you can have, and you can put that in the patient's medical record. So there's a record of what exactly was administered to the patient. Particularly for injectables or disposables of that sort.
Yeah, that's an interesting reminder. In hospitals, sometimes we take for granted because our pharmacies keep
Yeah.
track of all these things. But in a GP, you don't have a pharmacy. You have to uh, document it all this by yourself. So batch numbers, etc. In case of any problems,
When you are
you
getting
would.
the
Mm.
exactly when you're getting the supply from the medical device company, just ask them for a duplicate of the sticker of the product that is going to be administered. That's an easy way to keep track, because there are instances where there's batch recall or there's complications, and you need to know exactly what was administered to that particular patient at the time.
Mm. Yeah. Okay, there is actually one question in Slido which is a bit related to documentation,
Sure.
and so it is about the consent form. Are digital consent forms signed on a tablet or software valid, or do we need a physical signature?
I think we're moving towards the way forward where digital signatures are valid, even for contracts. Corporate contracts you're allowed to digitally sign these days. So yes, I would say yes.
Hmm. And also, is it mandatory to get a consent for every minor procedure? I'm not sure whether we're covering that later, but anyway, since that's just mentioned right at the top.
Right. I would respond to this by saying, if you are wondering whether you should obtain consent, you should obtain consent. And if you don't have a certain type of consent form, you document that this in the medical notes. We've discussed this. These are the risks. The patient consents. So if you are wondering whether you should do it, you should do it.
Okay, so even it's a simple thing like a toilet and suture, or
Yeah. Well, you
okay.
see, Dr. Allen, a lot of medical negligence claims often sometimes turn into a he said, she said, right? And
Hmm.
5 years later, 6 years later, they're saying, I wasn't advised of the risks. I didn't consent to this. I didn't know that this was one of the complications. So if this is information that you have noted down in your medical notes, then it's harder to debate this.
Okay, all right. We'll give you a break, Jen, and we'll get Jafar to to do some work now.
Yeah, great. Thank
Okay,
you.
yeah, we will get to the questions in the Slido. So thank you for all those who have submitted. Keep on submitting your questions, and we will address them. Okay, so we'll talk a bit about. Let's change gears and go on to medical indemnity.
Can I add
Um,
to the first
yes, Jafar.
question?
Yeah, yeah.
I just want to add to the first question that you asked. In medical legal disputes, how much weight does your proper clinical documentation actually carry in defending a GP? I would, in the hundreds of claims that we manage, right? One of the main factor that actually weakens the doctor's position is a lack of documentation, the lack of a proper documentation. So I would say that this is the factor that can sabotage their own position. They may have a solid practice, they may have done everything correctly, but when it comes to defending them, if they are not at proper documentation, that factor alone weakens their position. So I would say
Yeah.
yes, pretty much. Um, that's one of the most important. I think Jen said the same thing. It is the most important evidence with which they actually try to defend you. So
Eh, yeah, and actually before a webinar, we had we were having some conversation, and the impression a lot of us, because of these high-profile cases coming out in the media with multi-million-dollar settlements and so on. But would you say which are more common, that or GPs getting sued, Jafar?
the GPs claims arising from the GP sector is actually large in numbers. It's frequent. Yeah, it's you'll be surprised by at least 70 to 80% of the claims are arising from GPs, and whenever I say these GPs get shocked.
Hmm.
Because of the volume, perhaps it's not coming out in the media as much as a specialist case that comes out in the media, which attracts more attention. The severity is high when it comes to a specialist case. The amount is usually in the excess of 5 to 10 million, but GP's case is actually very frequent, more than a comfortable feel. Yeah.
So I think GPs better take note. Yeah. So on that note, there sometimes GPs may be confused between professional indemnity and indemnity for their practice. So maybe Jafar, you can elaborate and remind us again the differences and
Yeah.
the importance. Yeah.
So this is the most important point. An individual doctor does not equate to being a clinic. Right? A clinic is a separate legal entity by itself. I think that is something which a lot of doctors have trouble understanding. A clinic, it's an entity by itself. A clinic can be sued. A clinic would be required to pay for their lawyers to defend them whenever the clinic gets sued, whenever the clinic gets named. Shareholders or resident doctors or doctors who are running clinics mistakenly believe that their indemnity insurance would stand in for their clinic just because they are shareholders of the clinic. This is a myth. That's not true. The clinic is a separate legal entity requiring its own protection, and a doctor who may be owning the clinic is a professional. He is not the clinic. There's two
Does it
different.
matter? Does it matter whether the clinic is owned by a Sendirian Berhad, or if the clinic is just a owned as a what do you call individual doctor, not through a company? He just registers a clinic with the local council.
So
It's,
the clinic is still a separate entity, but the confusion happens whenever the clinic is a sole proprietor, right?
so property, yeah.
We tend to equate a sole proprietor's insurance coverage as being equal to the doctor's indemnity insurance, right? But if there is no clause which says there is a sole trader extension, if that extension is missing in the policy, it is deemed to be two separate entities. So it is always safer to look at it as two separate entities, even if it's a sole proprietorship and the doctor. For example, right, I can give you a blunt example. If a sole proprietor have employed a locum, right, and there is a case that gets that names the locum and the sole proprietor, the doctor's indemnity insurance would not stand in for the clinic, because the owner doctor's indemnity insurance would not stand in for the clinic. The sole trader extension only applies if the doctor owner's indemnity insurance has a clause called sole trader extension, point number one. Point number two, if he was part of the care and treatment of the patient would come to the clinic.
So that's a comment on Slido that should GPs include indemnity clauses in staff contracts or locum agreements related to clinic practice. Maybe both, either of you, uh, Jen, if you think.
Then you want to take it or?
You can take it. I will supplement.
Okay. So if GP include indemnity clauses in staff contracts, I think staffs are usually covered. Yeah, staffs, nurse, assistants are usually covered under the clinic. Yeah, it's vicarious liability, not an issue. But a locum is expected to have his own insurance if he were to practice in Malaysia. So if he doesn't have the insurance in place and if he had done locum, that is illegal practice by itself.
So, meaning, do I need to buy two different indemnities, one for myself and one for the clinic?
Yes, the long answer cut short is yes. If you're a clinic owner, your clinic must be indemnified by itself, and you as a professional must indemnify yourself. And also to go back to the question on locum and the staff, nurse, assistants are all part of the clinic coverage. They are covered there. But locums must have their own insurance, and clinics must put in some extra effort to ensure that they carry their indemnity insurance before they are given a locum appointment. Hospitals do that all the time, but some clinics do not. And then you have another big problem, right? The big problem in the market is a lot of doctors who are doing locum, especially government doctors doing locum. At the point of APC renewal, they would be expected to answer whether they plan to do locum. And if they thought that they wouldn't be doing locum at that point, then evidence of indemnity insurance is not required, which is usually the case. They say they are not going to do locum, and then they renew their APC, the government doctor, and then he decides to do locum thereafter. So most likely no one is going to check on his insurance. And these are the weak points. When they end up in a clinic and there's a negligence case that arises from their practice, the clinic gets into issues, the locum doctor is exposed without a proper insurance coverage. That's quite normal. That's quite frequently happening. Yeah.
So both the clinic and the locum doctor could be liable, and the locum doctor who does not have indemnity is in trouble by himself if the clinic does not cover him.
Yeah, he's supposed to have insurance. So the clinic is covered for themselves for hiring the locum, but I'm not sure whether are they going to be also liable that they didn't check that the locum is supposed to have insurance.
So on this point, Dr. Allen, clinic owners who are having locum doctors, they should ask for a copy of their insurance, and they should not take on that type of risk. And Jafar is right. This is a huge issue that I have seen also in my practice, is government doctors taking on ad hoc, small local procedures and consultations, and not necessarily, it's not always necessarily a medical negligence complaint. It can be something else, so be mindful of locum doctors and whether they have insurance or not as well.
I see in the job advertisement groups for locums, and also in DOBS, every time they say, oh, we've got a locum slot, this time, date, and so on, valid APC required. But I've never seen one which says valid APC and indemnity insurance required, and somebody commented in DOBS that if you require it, I think it's something like 70% of locum do not have indemnity insurance, which is quite worrying, I think.
Because the law is quite clear. The law says if you want to practice in the private industry, private sector, you must have indemnity insurance.
Okay. Is there a place to check whether or not the locum doctor has indemnity? That's the question in Slido.
The best is to ask them to show proof that they have indemnity insurance.
Yeah, I don't think there's any one place since they can get indemnity from multiple sources.
Yeah,
Yeah.
it's not like MMC or the NSR where you can check where they're attached to. We don't have any sort of system for the insurance industry.
Okay, let's change tack. In event of a claim, what are the common pitfalls that lead to indemnity coverage being denied?
This
And,
question is
and
for me, I guess.
either of you
Yeah,
Sure.
is
I mean, from
I
my
can start
perspective,
first if you want.
the huge one of common pitfalls that lead to indemnity coverage being denied is the aesthetic industry. Doctors doing procedures that they are not licensed and privileged to do. This is the most common thing and prevalent area that is coming up these days. And there's nothing. It's unequivocally clear. If you do not have an LCP and a procedure is not listed on your LCP that you are licensed and privileged to do, you cannot undertake the procedure. That's it.
I think Jed is spot on. A lot of GPs have been practicing. At least I should say from the claims that we are facing, have been seen to be practicing what they are not supposed to be qualified to do. For example, ultrasound. Right? There is a certain proper certification that they are supposed to take, and failing which, if they have followed the advice of a manufacturer, which seems to be a common problem, a lot of them are believing that the manufacturer's 2-day course or 3-day course is equivalent to they getting certified for a particular surgery or treatment, which seems to be quite a common problem in the industry. So that is one of the main factors why they are being denied coverage for practicing what they are not supposed to be.
Yeah, I think there was a recent case also about unlicensed and illegal practitioners who do ultrasound, and especially when it deals with maternal fetal medicine, which is highly specialized type of ultrasound. So I think it's this space which is a bit worrying because there's a lot of it going around.
Yeah, commonly aesthetics and ultrasound seems to be quite two main areas where the certification issue is causing quite a bit of a misleading effect.
And the
Okay.
thing about the aesthetic industry, Dr. Allen, is that when this happens and there's a complaint made and it's a procedure that was not licensed, the doctor usually says, "But I've had training in Korea. The medical device company have come to my clinic. They've taught me how to use the product. I've done it so many times. I've had such successful outcomes." But it doesn't matter. The fact is the LCP is very strict and it lists certain procedures. And if it's not on that list of procedures which you're licensed to do, you can't do it, unfortunately. So that's just the state of affairs for the aesthetic industry at the moment.
When they have a doubt, I think they should clarify with MMC whether a particular procedure should be carried out and what should be the certification if necessary. I think that's quite important.
And then, well, I've had a case like that recently, and the MMC will then refer you on to the medical practice division of the Ministry of Health, and they will come back with something on. I've had it recently, and they just said if it's not there, you can't do it. That's it. So there is, if you want a procedure to be listed that isn't listed, you have to go through a formal application process, but that too takes time. What I do believe is that there's two chapters that there's two guidelines that have been given by this aesthetic committee under the medical practice division, and it is going to be revised soon to include different procedures, additional procedures. But until that time comes, your practice is limited to what your LCP states.
Okay, thank you for that very, very important reminder, especially for those of you who are doing aesthetic medicine. All right. About the sum insured, Jafar, this one's for you. How
Yeah.
to decide how much to get covered for in GP practice?
The normal GP practice, the market trend is going towards 1.5, and this market trend is in response to largely what we saw in the Columbia Asia case, right? Because I think doctors have realized that if a case goes to litigation, it takes about 3 to 5 years, um, and that some measure that they have taken today need to be sufficient at the point of verdict. So therefore, I think doctors have started planning for the future, and we recommend that they do so. Right. So 1.5, if it's to do with GP aesthetics or obstetrics, 2 million, yeah, is at least something which we recommend.
Okay.
This is for the
Dr. Allen,
GP.
just on this point, what Jafar is saying is really important, because you're not only advising this for now, you're advising this sum to be covered for the future. And what we are seeing in the trends of the medical negligence claims is that the awards of damages are going up and up. So you're saying 1.5, which
Minimum.
might seem like minimum, which might seem like a lot for GPs at the moment, but with that, this is the trend that we are seeing.
Yeah. Given the fact that we are having close to, I suppose this year there would have been at least 1,000 claims in the entire industry. Going at that rate, I think, yeah, it's going to be quite a trend. And the worst part is no one is going to know what are these settlement amounts until 3 years or 5 years later. So no one actually has this transparency immediately. Yeah, we know that there's so many claims at inception stage, but we only know what's exactly the amount 3 to 5 years later. So even for us, it's like a black box. And going back to the question, sorry, Alan, I just want to go back to the question on the event of claim. What are the common pitfalls that lead to indemnity coverage being denied? I think it's important for the GP owners and the clinic owners to know the importance of notifying the insurer if there is a reason to believe that a particular event could lead to a claim. Yep. Whether or not any action is required, but if they feel that this may be a potential circumstance leading to a claim, they must inform the existing insurance company. So for example, we do have a couple of times when we see doctors who have received very stern warning from families that they're going to be sued and all that, but just because there was no exact follow-up 2 years ago, they have not notified the insurance company then, and then the letter comes 2 years later, they get shocked. And if you go to the insurance company and tell them that, last 2 years ago, they did threaten me, but only now they send a letter, the insurance company is going to say, why you didn't notify? So I think it's very important that doctors should know the importance of notifying the insurer as soon as it is practical, that there is a reason to believe that some event could lead to a potential claim.
Jafar, just on this point, I'd like to maybe pose this to you. One of the reasons maybe why doctors are reluctant to notify their insurers are for any repercussions. Their premiums going up. Maybe their coverage the next year might, be affected by someone like your insurance brokerage. So what would you say to doctors who are fearful of these kind of repercussions?
Thank you for that question. I think that really provides a lot of clarity to many who have asked the same question. So when you notify with no further action, that means you have not incurred any cost, right? And the cost only kicks in if there is a lawyer who's appointed and you have done some settlement, or you have started negotiating and you have started paying the legal fees. And then, yes, they have to start reserving an amount towards your eventual claim, and your premium will be loaded. But notifying it, no insurance company should actually load your premium for notifying, because they really don't know what's the problem, how big is the problem. So they'll just keep going. Yeah, without increasing your premium. So there is no penalty for being upfront and notifying the insurance company.
Okay, everybody heard it here, verbatim from Mr. Jafar Gopi, that they can come and notify without any legal or financial repercussions. But that's really important, because like Jafar mentioned, mostly when doctors have some complaint or they're anticipating some claim, they really do notify the insurance company and the lawyer at a really late stage. And then our hands are tied sometimes. Early engagement really helps to help assist the doctor. And sometimes, we can keep it at bay at a very early stage. But if you bury it and leave it for years and then a suit suddenly comes, you get served with a writ of summons. Then we have to work backwards a little bit, and it can be more difficult. So now we've heard here from the CEO himself. No questions for notifying.
That's plagiarizing. But yeah, I will just further explain. When there is a notification requiring no further action, really, we do not know what is the claim going to be. We don't even know whether there's going to be a claim at all. So there's no basis to load the premium. There's no basis to load. And there's no expense income. So that's the rationale behind what I say.
Okay. Message well taken. Engage early. Okay, this is one we revisit again, and probably just because there's another question. The second one or the third one now. Does indemnity cover mistakes made by clinic assistants or locums in my name, or allied health staff, or do they allied health staff, or do they need separate coverage? Maybe Jafar, just to reiterate again, because some may have joined us late.
Okay. So we need to read this question correctly. Does indemnity insurance automatically cover locums, nurses, allied air in whose interest? Who's asking? Let me read this right. If I'm the clinic owner, my indemnity insurance is going to cover against the negligence caused by all of them. It's going to cover me against the negligence caused by all of them. Okay. Having said that, nothing stops the plaintiff lawyer going after the locum directly too. So my clinic, say I'm the clinic owner, my insurance is not going to step in and protect the locum.
But it will protect the action of the locum at the clinic.
For the interest of the clinic.
For the interest clinic, if only the clinic is sued, but not the
Yes.
individual doctor. Yes.
Yeah. If it's nurses, allied healthcare, it's all part of the clinic, so it's fine.
Yeah.
Vicarious liability. Only locums people are supposed to have their own insurance. They are on their own.
But if the GP has only individual indemnity, but no clinic indemnity, so if the clinic is sued, that is not covered by his individual indemnity.
No.
And in fact, we had one webinar a long time ago where one of the GPs actually shared his experience on how the clinic gets sued, whereas he did not have any clinic cover. Oh, all right.
Yeah, they're on their own. If that's the case, they're on their own. The clinic has to bear the cost.
So the indemnity scenarios where the GP's indemnity is sufficient as stand alone.
Yes, very rare scenario where a particular GP is a sole proprietor and he doesn't have any locum, and he has a sole trader extension in his policy. That is the only exception. Let me repeat this. If you're a sole proprietor, you have an individual indemnity insurance, and you have got no locums, and you have a sole trader extension in your insurance coverage, then this is sufficient. You don't need to buy a separate clinic indemnity. Except for the description that I just made, every other permutations requires insurance for clinic separately.
Okay, very, very important point. So examine your insurance indemnity contract and terms. I think we will go on to the next section. Okay, medical legal. If a patient threatens legal action after a poor outcome, what are the steps a GP should take before even contacting a lawyer or insurer? So maybe this one for you, Jen.
Yeah, sure. This question was when we were planning our questions, it was initially what are the 3 steps you should do before contacting a lawyer or insurer, but we've changed it to generally what are the steps. And the first thing I would say is do not panic, take a deep breath. Okay, that's the first step I would do. It's not the end of the world, right? That's number one. Then, the second thing I would do is I would collate all the medical records. Maybe they are kept in different places, especially in hospital settings. You've got them in the inpatient, the clinic. In GP settings, maybe your record keeping is in different places. Collate everything. The third thing I would do is I will prepare a chronology of events and of the medical records. Maybe this is a long-standing patient that has been with you for several years. I would, document it and prepare a chronology that's easy to understand. And then the third thing I would do is, the fourth thing, then I would contact the insurer. But what I have seen before is patients get originating summons or writ of summons or a complaint form. They get it by hand, they get it by email, and they just bury it because they're nervous and they're scared and they're wondering where is this going to lead to. No, you have to face these things, and you have to face complaints head on. This is the world that we're living in now. Medical negligence claims are more prevalent. Patients are aware of their rights. It's reported in the news. You can't run away from it. It will always find you. So be proactive and don't worry, and early contact your insurer so you get the right legal support from day dot.
Yeah. Thank you.
Dr. Allen, I just see one interesting question here in the comments on records, on consent forms. I'd like to quickly answer. It says, when we do locum, most clinics don't have consent forms. Please advise. So what I would do if there's not a standard consent form, I would document the advice, the risks, the benefits, the refusal to treatment, refusal to specialist secondary care. I would document this in the medical records. So if there's no standard consent form, document it yourself in the patient's medical records.
Okay, thank you.
And this
Very
is probably
important point.
When you're coming in as a locum to different clinics, have different, SOPs. So this is just to safeguard yourself as well.
Okay. What's the most common reason GPs get sued? Just before we go on to the the questions we've arranged earlier. Jafar, maybe you can share from
What's the common reason?
the most common reason GPs get sued. At the top of your head, yeah.
Yeah, unfavorable outcome is one of the main ones. What they were promised and what they got, the difference between the actual and the expectation, and then it's usually communication of it, right? And how they have handled it before and after the surgery. Yeah. That has been one of the main reason. Lack of communication, lack of, do I use the word service? I think so, yeah. Especially when the outcome is not as expected. I think that plays a very important role. Being there for them, that really matters. Yeah.
I think also, yeah, and document what you've told them, what the expected outcome will be. I think otherwise, yeah, I think the expectation nowadays is very, very, very high, and sometimes beyond reality. Even for patients with advanced terminal illnesses, they expect to walk out cured.
Just on this point, Dr. Allen, if I may, on effective communication, because we see this quite a lot, not just with GPs, but also with specialists. And I found this study that was done by Siegler in 1998. It's medical ethics, and it's called the 4-box model. So it talks about practical clinical ethics, and there's 4 factors: medical factors, patient preferences, quality of life, and external considerations. So for medical factors, you're looking at the medical problem, the goals, the success of treatment. Patient preferences, that's the risks, benefits, and capacity. Quality of life, the patient's lifestyle, the recovery time, the results from the treatment. And external considerations would be maybe finances, personal interests. So all of these factors can only be considered if you have had effective communication with the patient. If you are doing a procedure that is going to have significant scarring, somebody like Cindy Crawford would not want that done to their leg. They would want to know of the risk of a severe long scar down their shin bone, if they were someone, like a model or something. So you need to have effective communication to be able to assess what type of patient you are dealing with. It's really, really important.
Yeah. I know somebody during her junior training years in a government hospital. I mean, sometimes all housemen, medical officers, we are thrown into the ER and expected to do procedures like suturing. And then she was very nervous because she had to suture lacerations in the finger of somebody who was a musician and was a drummer. He said, "Oh my God,
Exactly.
what if I don't do a good job?" you know,
Yeah.
those are the
But
days.
if you
Yeah.
don't spend the time with the patient, you wouldn't even know he's a musician to begin with. There has to be that trust and that time taken to have that effective communication.
Okay, very good reminder. Here's a question on what about emergencies outside your practice? For example, if there's an accident outside your clinic, uh, you know, what legal protection do GPs have? It's not within the confines of our practice,
Yeah,
or
we
perhaps at home if you're doing a house call or something,
yeah we
or
discussed.
aeroplane, or even the airplane.
Yeah.
If you're
Okay. So
yeah.
this actually happened last week. Friday last week, there was a Singapore Airlines flight from Singapore to Milan. There was a middle-aged man, who collapsed, and the cabin crew were there with them and had an AED and called for a doctor on the flight. So the doctor then attended to the patient, administered CPR and the AED, but to no avail. When the flight landed in Milan, he was suddenly met with a translator and police. And he suddenly thought, oh my gosh, have I done something wrong? Even though, unfortunately, the man didn't make it. But what he said was, being a doctor, it's my ethical duty to help. And in this case, the patient's wife and the medical staff all thanked the doctor for his efforts. But he suddenly was faced with this question, did I do the right thing? So in emergency situations, practice of medicine is fundamentally guided by ethical principles. So I would always remind myself that, number one. Number two, we discussed this before, but there's no good Samaritan law per se. But there are instances where consent is not the same standard in emergency situations. And an important thing to also know is that if you're worried about any criminal liability, we have the Penal Code, Section 92, which has a provision that says acts done in good faith for the benefit of the person without consent. So this section protects practitioners who render emergency services in good faith. So that would be my, response to this question.
What if the doctor say you're on a plane, but you are in a specialty like psychiatry or dermatology, never dealt with any real acute emergency, like has somebody having chest pain, a heart attack, and collapse, and should they just keep quiet or expose their
You can answer this one.
inadequate?
Do no harm is the Hippocratic Oath. So, I mean, I think most people these days, even non-medical people, even in corporate, sometimes we have CPR training, basic resuscitation training, and also cabin crew are trained in resuscitation as well. But usually there is someone there to help.
Sure. Okay. There was a question on Slido about telemedicine. Is it covered? And actually, we have this as one of the questions. So, what about our legal responsibilities or Malaysian law, which covers online consultation or telemedicine? In the first place, are these covered at all? What extra things should we do?
What extra legal responsibilities do GPs have? So in Malaysia, currently, there is no legislation governing telemedicine. So what does that mean? Doctors are left to self-regulate. And when you're left to self-regulate, you must make sure that you are taking extra caution. So I decided to take this upon myself, and I did 2 experimental telemedicine consultations. And the first one I did lasted approximately 45 seconds. And I was issued with an MC. And the next one I did was a little bit more comprehensive, but it was 2 minutes. But if I was going into a GP clinic, would I be having a consultation lasting for 45 seconds? My complaint on both instances was a migraine. So the first instance, the doctor believed me to have migraine and said, okay, do you need the MC? Okay, I'll issue it through that. The second consultation that I had was a little bit more detailed, where she asked me, where is the pain? How is the pain? Was I having any vomiting? Was I allergic to any medication? It was a little bit more thorough. So if it is an area of medicine that is not regulated, I would be having a lot more caution than I would be in face-to-face, in-person consultation.
What about you, Jafar? Would Dr. Shield cover teleconsultation?
Yes, teleconsultation is covered. Teleconsultation is is definitely covered.
So I think my understanding also, I mean, it is, although it's online, but the same general principles apply in terms of documentation and what you can do. But usually we would advise also, if something cannot be solved in the teleconsultation, is to defer to in-person or a real visit, and also don't handle emergencies online. I think that's in the consent form. I think we usually advise not to, deal with emergencies online, or at least state it. And I'll usually defer my colleagues to the current online healthcare guidance issued by the MMC, although it's not law, but at least it's guidance by the authority. So maybe you all can read that. Okay, we've got 5 minutes more, but we can extend a little bit if there are more questions. So here's one: GPs and documentation or refusal. How should it be done properly? Say we refer a patient and then they didn't want to go, or we advise admission or the patient refused, or advise to have a scan and they don't want. What should we do?
Okay. Should GPs document? The answer is yes. You should document your advice, which is, for example, to seek urgent admission to hospital, for example. You should document then the patient's refusal, and you should document the risks, what risks you have advised to the patient if they do not seek emergency care. So that is unequivocally clear that they know the risks inherent with delayed admission or whatever the case may be. When in doubt, document.
Okay, very, very wise. Okay,
And
there's one.
unfortunately, Dr. Allen, GPs, unfortunately, they always say, but it takes so long. So many patients are waiting. I don't have time to be doing this. I'm really, really, really sorry. This is now a part of your everyday practice. You have to spend the time to document. Just like for insurance purposes and admissions, you have to take time to apply for the GL. The GL gets denied. You have to put in justification and clarification. This is all part of a doctor's job that maybe 30, 40 years ago wasn't the same. It is now. So it is a part of your practice. So the sooner you come to terms with it, it might not be a little bit less painful. And we now have electronic medical records, which can hopefully help fasten this pace or this burden. But it is now a part of your job.
To add to
sorry, go ahead. Yeah, go ahead.
Every time there is a claim, actually not every time, most of the time we have a claim, the doctor usually says, this is the only time I did not document properly. This is the only time I missed out the details. This is the only time I did not include that I had given him a referral letter that he refused to accept. This is the only time. It always happens at the wrong time. So yes, please practice proper documentation, because that's very, 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 very important. Can't overemphasize the importance.
Okay. Yeah. There's a question in Slido about concerns about complaints in social media, and this is a common recurring theme in our forums. What if the patient complains about us in social media? Number one, does indemnity cover this? Number two, what's the best course of action?
If a patient
Either
complains on
in,
social
in
media,
social media. Yeah, this is a common thing we see nowadays. First reaction, instead of doing through the proper channel or a grievance mechanism, which really every clinic is supposed to have, but first thing the patient do is they go and post on social media.
right? Your indemnity insurance does not cater for you to sue someone who have made a remark about you in social media. Yeah, it doesn't allow you. It doesn't pay for you to sue, right? So that's something which I need to clarify. That's usually a separate case by itself. Yeah.
What are your thoughts, Jen?
Yeah. Okay.
What should
So
the doctor do? Yeah.
yeah, it's challenging times these days, and I understand social media is a great way for doctors to promote their practice, but they must do it in a way that is in compliant with the MMC and MOH rules. Okay, so you can do that to educate and engage, but you must be cautious when you're doing this. So say, for example, if there's a complaint that's made online, you've got maybe 500 comments of positive 4.9 star reviews, and there's this one horrible comment that you are so upset about and you want to get rid of. What's the first thing you should do is you should maintain professional. Don't respond out of anger and spite. Okay, you can't contact a lawyer and look about how you can deal with this comment. We have done this in practice before, where we've then, sent a letter and represented the doctor and had comments removed that were defamatory of sorts. You need to speak with a lawyer and see if it is something that that can be done. Just while we're on the topic of social media, I would want to stress that the MMC and mostly the MMC have a lot of guidelines on social media and presence and what is allowed and not allowed. So you have to always maintain patient confidentiality. That's number one, and you need to understand, as if you were using it yourself as a social platform, the permanence of online content. It remains online and accessible. And just because you deleted something doesn't mean that someone else didn't take a screenshot of it. And what else did I want to say? Verify your content before sharing. So if you're maybe discussing something that is of educational purposes, make sure it's you put the date in which research was given for this, because things can develop and change as well. And of course, online you have to avoid self-promotion. The best doctor in town, number one GP clinic that gives 5-star service, the best one in town. When a patient goes to sue a clinic or a hospital or a doctor, the first thing they do is they look online and see, how is this doctor holding themselves out? And usually they say these kind of things, the best number one specialist in this, and so be careful of your online presence.
Okay.
Sorry, I read the question differently. I was thinking it was more about patients or fake patients posting negative comments about the doctor in the Google page or the Facebook page.
I ran with it.
Yeah, so that's why I said no, because doctors usually call up and ask whether they can use their indemnity insurance to go after the unhappy patients. But most of the time, these unhappy patients also do not reveal their true identity. So we really can't go after them. And recently there's also been another issue whereby the doctors get threatened. They get threatened saying that this patient is going to go viral, go to live and complain about them, and we need to appoint a lawyer immediately. We need to respond to them immediately. We need to pay them immediately. And I always tell them, stay calm. Yep, stay calm. We cannot work on extortions. We cannot work on the threats. That is not going to be the way to go. Yeah. If you've done something and if you don't even know whether it's truly negligent or not, the lawyers will have to be appointed. We need to look at the case. The insurers have to agree. If it's truly negligence, then of course, yes, we have to do whatever is necessary, but we are not going to work under threats. From our side, we definitely will expedite to appoint a lawyer as soon as possible, but I don't think even the doctors should work under such threats. That is
So
equivalent to black.
engage you early on if we face such threats. It's like the patient threatening to go viral and so on.
I think that's really completely a wrong idea. I mean, threatening to pay on the spot, or that's really wrong. I mean, if genuinely there is some mistake, fine. We are going to listen to you. We are going to pay for alternatives and do whatever that's necessary, but not under a threat saying that, oh, yeah, I'm going to go live now if you don't transfer the money in the next few minutes. That's completely wrong. Yeah, I think the doctors need to just hold their ground. Of course, talk to us, and we'll advise them accordingly.
Okay. Quickly, there are few miscellaneous questions. WhatsApp consultations, Jen, are they covered under standard indemnity or even allowed?
Yeah, we don't have restriction on the communication. Yeah, we don't have. I have not seen anything that is a channel being used to deny a claim. Yeah. As long as they are in alignment with whatever rules and regulation of that particular country, it's fine. So if there's an explicit guideline or a law, then obviously insurance will be null and void. But if there's
Yeah,
no,
unfortunately, the MMC in the latest 2025 online healthcare guidelines has specifically stated that social media, including WhatsApp, are not allowed for teleconsultation
then
or
that
even phone calls or even phone calls.
phone calls are not allowed. But
Yeah, it's
telephone is
stated
allowed.
in the guidelines, but it's that one is a matter of debate. But they have specifically stated WhatsApp and social media. Unfortunately, that this is between doctor and patient. It is not between doctor and doctor or doctor and hospital and so on.
If
Between
there
doctor
is
and
such,
patients, yeah, yeah, it's
if there is a
stated in black and white.
if there is
Mm,
such a clear directive, then obviously that takes precedence over anything. Yeah.
Dr. Allen, just on this point, there have been cases where, a doctor has become fond of the patient. They've developed a very close doctor-patient relationship, and the doctor gives the number and says, "Look, if there's anything, you contact me." Right? And this has actually happened in practice. The patient has a number, WhatsApps the doctor and says, "Look, for example, this is, maybe it's a diabetic foot, and they sent a picture of the worsening foot to the doctor, and the doctor has not said, look, looking at this, you need to go straight to A&E and get urgent care. The fact that that line of communication has been opened and the advice wasn't clear cut and straight that they need to seek emergency care when they did in fact need to, is used in evidence, and then a finding of negligence can arise. So I can see why this MMC directive you're saying is trying to limit this communication, because it can go from being, in good faith to assisting the patient and saying, look, if anything happens, you can call me. But it also exposes you to this risk that if you are aware of something and you don't give the correct advice, you are then liable.
okay, so very important. But it is in black and white that the MMC has said you should not use WhatsApp
So
for
that goes also,
consultation.
yeah, that phone sometimes is used by the clinic nurse and scheduling
Yeah,
appointments and
I think
whatnot. So
that's separate. WhatsApp for scheduling, making appointments, it's okay as long as it's not online healthcare advice.
right, but that line of communication, the patient then can open up and say, "Oh, doctor, I know my appointment with you is on Friday, but look at this, the skin is worsening here. What should I do?" Then
Come to the
how?
clinic. I would
If
say
he
we
but if
can't
he didn't,
provide advice on WhatsApp. Please come to the clinic. I think
yes,
that
absolutely.
would be the best way.
But it
Uh,
depends on the specific situation. It could be come to the clinic, or it could be go to A&E now, or it could be,
mm,
it's case by case basis. But you can
mm.
see why WhatsApp and social media can have implications in this way.
Okay, we are running out of, we are overshot a bit. So quickly, just to couple more questions on the Slido. Intra-articular injections, are they allowed in GP practice? or do they have to demonstrate they have attendance certificates for workshop on intra-articular injection or qualified as such?
I think the best person to answer this would be you, Dr. Allen, because I'm not
Yeah,
scientific.
I think,
So
yeah, I would not do something I was not trained in the
yeah.
clinic. And if something goes wrong with the procedure, then these questions of what's your training, what's your qualification for that procedure will arise. So I think you just be careful because it may not be an intra-articular injection. It could be some other minor procedure which you may or may not have experience. But not all procedures have certification or training. So you may be called up, but you just need to be mindful of this, I think.
Dr. Allen, just on this point,
Yeah.
the standard of care that is expected of a first-year medical officer and a 35-year general practitioner in clinic, the standard of care that is expected is the same. It doesn't matter how senior or how junior you are in practice, you still owe the same standard of care to a patient.
Yes. Okay. Jafar, sorry,
Yes.
there's one question there at the bottom. Do you decline subscription from high-risk doctors?
To ensure a sustainable.
Sustainable portfolio for
So
the indemnity.
we don't decline, but we have priced it in a way that certain high risk classifications would be slightly higher than our direct competitors. Yeah. Yeah,
Okay.
that's how we manage our portfolio sustainability.
All right. Okay, but then finally, just maybe summarize what proactive habits can GPs cultivate to become legally ready doctors? Jen, maybe can summarize.
Okay, I would start, where we started, which is to maintain comprehensive, accurate, legible, if it's written, documentation. That would be number one. Another thing I would also like to highlight is, in cases of emergency, ensure that not only yourself, but your staff are trained with dealing with medical emergencies. I think this often gets slept on sometimes because suddenly if an emergency arises in clinic, the nurses are looking at each other and suddenly everybody's panicking. There needs to be protocols and everybody needs to be trained with emergency situations. And I think to lighten this, medical negligence claims are more prevalent and on the rise. So with saying that, engage with your insurer. We know that there's no severe repercussions and notifications of complaints. Sometimes they don't materialize. So engage with your insurer, engage with your lawyers, and just practice it.
And document as completely as possible.
Yeah, when in doubt, write it down.
Okay. I think we've gone past time.
Dr. Ellen,
Any last words? Yeah.
I would say
Jafar, go ahead.
a couple of things. Because the topic is about GP practice, we must ensure certain things for the clinic owners to take note of. Clinic owners understand your clinics are a separate entity, therefore insure them. Point number one. Point number two, ensure the locums that you hire come with insurance to cover themselves. Point number three, look at all your stock of drugs and vaccinations to ensure they are not expired. This also leads to claim, right? And point number four, if you have employees who are working with you, ensure you have proof or proper documentation of employment, right? Even clinic assistant or nurse, there must have been a real evidence of employment, or else they are not supposed to be there. Yeah. So these are certain points that I just wanted to emphasize for clinic owners. That's all.
Okay,
and lastly,
thank you. Yes.
parting words, keep up to date with the MMC and MOH guidelines. Every couple of months there's something new, like you mentioned about this WhatsApp communication. We have guidelines also on telemedicine, so keep up to date. MMC have listed on their website all the guidelines and codes that are there. And then one thing that we didn't really touch on today, Dr. Allen, is patient confidentiality. So maybe next time we can discuss on that. But with the emerging electronic medical records and handling of records and patient identifiable data. Make sure you are maintaining patient confidentiality.
Yeah.
Yeah,
And it's
very
worth
important.
emphasizing one more time that a manufacturer's certification may not completely constitute to someone practicing a particular usage of a machine or a treatment. They need to seek clarification before they onboard a particular treatment, right? That's all.
Okay. So with that, I'd like to thank both of you, um, Jen and Jafia, for a very interesting hour, which we've exceeded by about 15 minutes. But I think these are all very pertinent questions to practice. And I hope that everyone, GPs especially, have benefited. And I think it's better to be proactive rather than reactive, and I think prevention is better than cure, not just for medical illnesses, but also medical legal illnesses as well. Uh, Here is how you can claim your CBD point. Thank you for staying on right until the end. So for the doctors who have joined us, you can go to the link dops.my/101125 or scan this QR code, and it's a Google form to um, to submit your attendance. Okay, so this form will be valid until midnight tonight. So you can, those of you who have caught it, please watch right to the end, and then you can still submit your form. But the form will be deactivated after 12 midnight. Okay, so thank you all again, and I will uh, wish you all good night and have a great week ahead. And thank you again, Jen and Jafia. Oh, all right. Did anybody have any problems with the form submission? I tested it just now. It was working fine. All right. Let me turn off that banner is blocking. Okay. So the link is dops.my 101125, or scan the QR code, not with the MMA app. This is just with your QR code scanner or camera. Your phone supports a QR code, and then it will take you to the link, and then it's just a short form. Fill in your details and submit. Okay. So if and this will remain there on our stream, so you don't have to worry if you have come in late, because you can watch right to the end, and the link will still be valid. Okay, so I wish you all good night, and won't take too much of your time now, and I'll see you in the next one. Okay, I'm going to end the stream.
Thank
Thank you
you.
all again. Bye bye.
Thank you, Dr. Allen. Thank you, Jafar.
Thank
Thank you.
you. Yeah. Bye. Okay, the